150,000 Israelis apply for gun permits. Plus, scholar David Kopel dissects oral arguments in the Supreme Court's latest Second Amendment case. That and more on this episode of the Weekly Reload podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com and a CNN contributor. You can head over to thereload.com if you want to check out our latest news stories and sign up for our free newsletter to keep up to date with what's going on with guns in America. You get one email a week for free, and it gives you everything you need to know for that week. Of course, if you want to go a bit deeper, you can buy a membership, get access to all of our member exclusive pieces and our additional newsletter that goes out on Sundays. This week, we are discussing the Supreme Court. The court has now had oral arguments in the first Second Amendment case it has taken up since the landmark decision in Bruin last year. And we have with us a gun rights scholar, one of the best out there, who we had on about a month ago because he filed a brief in this case. David Kopel, the research director of Independence Institute, is with us today. How are you doing today, David?
I'm doing good, and thank you for having me.
Yes, absolutely. We appreciate you coming back on. You know, we talked about the lead up to the case, and now we're going to talk a little bit about where things have come down after oral arguments. You know, obviously, they're not 100% predictive. What gets asked in oral arguments doesn't guarantee that a justice is going to go a certain way based on how they performed in the questioning, but you know, you can take away some things, right? I mean, it's not a fruitless thing to look at these oral arguments. There's quite a lot in there that we can probably peel away. So let's start with just your brief itself. You know, last time you were on, you described your advice to the court in the amicus brief, which dealt with how this federal law is structured. This is the law that bars people who are under domestic violence restraining orders from owning guns. And it has two sections, two types of restraining orders that it can apply to. And you had said that the second part had an issue. Can you just explain that argument real quick? And then this got brought up in oral arguments.
Yes.
How did you think that went?
Sure. So Volume 18 of United States Code, Section 922, subsection G8C, Roman numeral 1, bans gun possession with up to a 15-year prison sentence for mere possession in the home by someone who's under a domestic violence restraining order when the judge who issued that order found that the person poses a credible threat to an intimate partner or child. Subsection C, Roman numeral 2, also imposes that same kind of ban without any judicial finding at all, according to the statute, and is simply an order that by its terms, orders a person not to do violent things against the intimate partner or child.
Right. And your brief had an issue with that second part, right?
Exactly. We said that based on the Bruin methodology of, you look at the original meaning of the Second Amendment as that's elucidated by history and tradition, that there is a history and tradition both before and after the enactment of the Second Amendment of restricting arms rights for individuals who have been found to be dangerous on an individualized basis. And so C1, with the finding of a credible threat, is not an infringement of the Second Amendment in the sense that of targeting somebody like Rahimi to restrict his arms rights. Whereas C2, which doesn't require any finding of anything, we argued was a Second Amendment infringement. In the Solicitor General reply brief on behalf of the U.S. government, our amicus brief, that was the only amicus brief in opposition to the government side that the government replied to, and they said no, that's okay. The government can come up with legislatures can identify categories of people, and they don't have to have a specific finding about an individual. And that, as you said, that did come up in oral argument initially by Justice Alito. Justice Gorsuch talked about it, and Elizabeth Prelogar, the U.S. Solicitor General, who argued the case, obviously talked about it with them, and then even brought it up again in her rebuttal phase of oral argument.
Yeah, and it seemed like she kind of retreated from the brief in that her argument was in oral arguments was essentially that the judges who issue these orders basically are finding that somebody is likely to commit violence, even under that second paragraph, that they wouldn't issue a permit or a restraining order if they didn't have reason to believe that that the subject might actually commit violence against their partner.
Exactly. She made and this was not something that the U.S. government had argued in its briefing, but she did, as you say, retreat to a more defensible position in oral argument, which is that any court order under necessarily includes a implicit finding that the person who is ordered don't do that, that the judge must have found there's some likelihood that the person will do that, and that's why the order was issued. So even though the statute doesn't say you have to have any factual finding, she argues that there's an implicit factual finding if you drill down deep enough behind the statute.
Yeah. So she's kind of arguing that basically 1 and 2 are the same in practice, I guess, is kind of her.
Exactly.
Okay.
Which
yeah, go ahead.
Which is not really true, because there were 2 real solid amicus briefs from public defenders. I think one from the Alameda County Public Defenders and some others, and another from the National Association of Criminal Defense Lawyers, which, based on their own experience, say, no, restraining orders are given out quite promiscuously in many jurisdictions. And this idealized version presented by the Solicitor General's office is just not true. That it's very common for judges to issue them with no real factual inquiry at all. That it's just safer for the judge professionally to issue restraining orders all around, and then because then if somebody does something bad, then the judge suffers a reputational problem that he or she didn't issue a restraining order beforehand. Even if there's very little or no risk that the person to whom the issue is ordered is actually any danger to anyone.
Right. And she rebutted that, I guess, with this. She brought up a legal principle that, to my understanding, and maybe you could give us a little better understanding of this, but essentially that the court has to assume that lower court judges are operating properly, unless they have evidence to the contrary, right? That they're supposed to take in good faith these judges issuing these restraining orders. That sort of was her rebuttal. That was my understanding.
Yes, and that's exactly right. The problem with her argument is the amicus briefs we just talked about from the public defenders show that that's not the case. That there's plenty of evidence that judges are not always being factually thorough or having a good solid basis for issuing these kinds of orders.
Okay. And so I guess on your particular brief, which, was pretty narrowly focused on this dichotomy between these 2 aspects of the law. In fact, you said it could be fixed with a single word change, right? From or to end. Where did you feel the judges were coming down on that, or the justices? Do you think they're inclined to knock out that second clause?
I think it's always perilous to predict results based on oral arguments. I remember there was a administrative law gun case that the court heard back in the the 90s, and one of my lawyer friends went to oral argument and said, "Oh, this was great. We're gonna win this one 9-0," and it did turn out to be a 9-0 case, but the other way. So it's I'd say what you can say for sure is the justices were engaged in the issue and thinking about it seriously.
Right.
And
yeah,
so there's,
I guess, from
some hope that the decision will say that C2, the thing with no requirement of an actual factual finding, that they might say that's an infringement.
Yeah, from your perspective, I imagine it's better that they brought it up a number of times rather than they didn't talk about it at all.
At least, exactly. At least they're paying attention to me, as the 15-year-old girl said.
There you go. Now, we mentioned that the government kind of retreated on this question a bit, and I think retreat might be the word of the day for these oral arguments on both sides, honestly. But let's stick with the government for a moment here, because I think she was really retreating, the Solicitor General, right from the get-go. There's a lot of talk going into this oral argument about the two standards that might be presented. You had the government's preferred standard, which is law-abiding, responsible. If you're not law-abiding or responsible, then you can have your guns taken away, essentially. And you had sort of the ACLU talking about it, a different standard, the dangerousness. You've had other amici. I think you've sort of, as we just went over, talked about a finding of actual dangerousness being required for guns to be taken away. Now, there's obviously questions about how what lifetime prohibitions and things like that weren't as much at issue here. But the government came in and was articulating this, and then immediately had several justices questioning their law-abiding, responsible standard. What did you make of that?
And the question is, well, when you say, and obviously, excuse me, the U.S. Supreme Court, in its major Second Amendment decisions, has certainly used the phrase law-abiding, responsible citizens many times. So when some of the justices said, well, why are you raising that as the standard? I think Solicitor General Prelogar said, well, we got it from your cases, so what are you going to expect?
Right. We learned it from watching you.
Yeah.
Yes.
But she also, in the back and forth, and this was even true in the government's opening brief, that they read that even the government concedes that means dangerous. That if you're not law abiding in the sense that you, as an example we talked about in our brief, is you're a habitual repeat overtime parker. Every day you pay the meter for 2 hours and you stay there all day for 8 hours, and you've been convicted of that 100 times. You're clearly not law abiding in some sense, but it's not really danger that you're creating by doing that. So they seem to retreat on that, but then they take back the retreat by saying basically Congress can categorize anything it wants as supposedly a category of dangerous people.
Yeah, that seems like a pretty big
like
loophole.
Somebody, for example, who uses marijuana but never uses marijuana when they're carrying or shooting or doing anything with a firearm. So what's the danger there? None, obviously, which is why the Fifth Circuit in the U.S. v. Daniels case this summer said the 922 G3 ban on gun possession by anyone who is an unlawful user of a controlled substance. The Fifth Circuit didn't throw that statute out, but they said, as applied to Mr. Daniels, who is a marijuana user with no indication of ever using while intoxicated, as applied to him, you can't enforce the federal gun ban. And of course, the Department of Justice disagrees with that. They filed a cert petition in the Daniels case. So even though they claim they're only arguing for dangerousness, uh, they define dangerousness so broadly as to basically be anything Congress says it is.
Yeah, they also had this conception where she didn't want to say that they only believe in dangerousness. It seemed like because she was trying to preserve these prohibitions on people whose gun ownership presents a danger, but who are not themselves consciously attempting to be dangerous, if that makes sense. So her examples were people who are mentally ill, or people or children was the other one.
Yes.
And so
I think that
seemed to want to go all the way to
a legitimate thing. You think of some dangerous
people. Dangers.
Right. So there's some folks who are, the reason they're dangerous is because of the things they intentionally do. They're robbing the liquor store with a handgun. But somebody who's mentally ill might not be convicted of a crime because they'd have an insanity defense they could raise. Mm-hmm. So you're not ascribing moral fault to that person, but it's still dangerous for that person to have a firearm.
Yeah, that seemed to be why. That was her explanation for why they didn't just say dangerousness, why they said law-abiding or responsible because of these other categories. That was her reasoning for why the government went the way it did. But yeah, as you're saying here, it seems like they have an extremely broad definition of dangerousness, and that goes to something I believe it was Justice Barrett. Actually, Justice Barrett had a pretty good, I thought, rebuttal to the idea that the court came up with the law-abiding, responsible standard. Like, yes, they do talk about how in Heller or McDonald or Bruin that the people affected were law-abiding and responsible, but she said, they weren't necessarily trying to create a standard with that. They were just saying that they're kind of like setting a floor, like these people that are being affected in these cases previously, none of them had any sort of criminal record or anything like that. And that was kind of their way of talking about it. Didn't, at least to Barrett, it didn't seem to set a test. She kind of objected to that. What did you think of that?
Yeah, that's true, but it's a fair argument. But it's also true that in a Supreme Court opinion, every word gets parsed very carefully by the lower courts, and there's rules in basically every federal circuit court of appeals that even something that is clearly dicta in a recent U.S. Supreme Court opinion is almost as binding as the holding itself. And that's less true as you go lower on the judicial food chain. But it certainly the Supreme Court, it's practically like, reading the Bible, in the sense that every little word matters a lot and gets taken very seriously in interpretation. So, that one of the benefits of this case is the Supreme Court can clear up some of that confusion.
Yeah. I think that's always been my perspective on it too. Like, a lot of people like to talk about dicta and how it doesn't apply, but I mean, I understand it's not binding, but it's almost binding, right? So if the court doesn't like this idea that people are taking a law-abiding, responsible standard from what their previous cases, then it probably should say something about that, right?
Right, that's right.
And speaking of which,
if you said, if you just dismiss dicta, then sorry, if you said, well, anything the Supreme Court says that's not the holding, we can just ignore that. Well, then you'd have Heller, and it's like, okay, great, we can't ban a handgun in the home, and other than that, we don't know anything about what the Second Amendment means. I mean, the Supreme Court is the Supreme Court because it's writing to give guidance to all the lower.
Yeah.
No, and in cases that are not just the same as the precise one the court decided.
I think that's an important point that kind of gets looked over, even occasionally for convenience sake. Like, oh, I like this dicta, I don't like that dicta.
That's constant, and that's what lawyers do on all sides.
Sure.
You're representing your client. You don't like something, you call it dicta. And maybe you're right, but that doesn't mean that the judge is necessarily going to say it has no bearing on what I have to do as a judge.
Absolutely. But so speaking of this of Justice Barrett and perhaps the idea of them clearing some of this up, maybe setting a new standard to judge who can and can't be disarmed. She did explicitly bring up one of the cases in the lower courts, Range, which is another, that is actually a Third Circuit case out of Pennsylvania that dealt with somebody who's a felon because they committed food stamp fraud. They lied about a couple $1,000, or they had a couple $1,000 fine, but it made them a felon, so they're prohibited from owning guns for the rest of their lives. And the Third Circuit, not the Fifth Circuit, which is the one you hear a lot about because they tend to be on the cutting edge of these gun rights cases at this point. But the Third Circuit, which is a little more moderate in some senses, they did the same thing as in the marijuana case you mentioned. They said, as applied to Mr. Range, this prohibition is unconstitutional under the Second Amendment. And this came up explicitly at oral arguments. What did you make of that exchange?
The Range case was a guy who committed food stamp fraud of over $2,000 in the early 1990s in Pennsylvania. And the crime for which he was convicted is actually a misdemeanor in Pennsylvania, but it's a misdemeanor for which he could have been sentenced to up to 5 years in prison, even though it's a misdemeanor. And that's included within the scope of 922G1, which is commonly called the felony prohibitor, but it also applies to a lot of misdemeanors as well.
Right. And to be clear with these cases, and a lot of them, like Range never actually served any time in jail. So it's just something. The way the law works is kind of funny, and I think to the average person, some of these things, like he could have served. It was a misdemeanor, but he could have served 5 years in jail, so it qualifies as a felony under this, or the same thing as a felony,
equivalent to a felony law. Yeah,
even if he never served any jail time at all, which he didn't.
Right.
So you get these kind of wacky circumstances, and I think Range fits in there.
It does, and so the Third Circuit in en banc, meaning not just a 3-judge panel, but all the active judges of the circuit sometimes get together en banc to hear very important cases. And they ruled that the G1 can't constitutionally be applied to Mr. Range because he did this food stamp fraud. He and his wife were pretty poor, but they in the application they understated their income to make them food stamp eligible, which was fraud. And so then they ended up paying a fine of over $2,000 for the fraud. And now we're a quarter of a century later, and he's lived a honorable life ever since. No problems at all. And sues and says, well, I'd like to have a gun, but I can't because I'm on the prohibited persons list. And the Third Circuit majority agreed and said, as applied to Range, you can we'll grant an as applied exception to Mr. Range so that he can have a gun, even though we're not finding G1, the felony and misdemeanor prohibitor, in itself to be unconstitutional.
Mm-hmm.
And this did come up, as you said, at the oral argument, and the Solicitor General Prelogar took the view of, no, there should never be as applied exception. Like as in Range on the food stamps, or like as in Daniels on the marijuana user in the Fifth Circuit case, that no, once Congress sets the category of supposedly dangerous people, that's it. And courts should never find that anybody within that as an individual is an exception to that category of supposedly dangerous in general.
Hmm. Yeah. And she also kind of punted on the question a little bit too, right? So she said, we'd like to have the opportunity to talk about people like Mr. Range she didn't say misderange, but people in those circumstances
Yeah.
in a future case, right? That was sort of, she didn't
Right.
get into why somebody who cheats on food stamps should be disarmed, for why they're dangerous, right? She didn't get into all of that.
Yeah. No, and they've filed a petition for certiorari, but also in the Range case, as in the Daniels marijuana case, and on both of them said, even though we filed a petition, don't act on it yet. Wait till you've decided Rahimi, and then grant us a cert petition. Then grant the cert petition, and we can do those cases under whatever the Rahimi standard is.
Right.
But they don't have to
So
do it that way. Then another approach would be to grant cert in Range and Daniels and have briefing on those this term, and then they could issue, collective opinions on Range, Daniels, and Rahimi, and give the lower courts lots of guidance by deciding all three cases.
That Justice Gorsuch had a number of questions that kind of implied that maybe that's what he wants to do, or at least he was laying out that this is an option, because he was saying we don't have to rule on all this stuff in this particular case, right? This is a facial challenge. If there's one scenario where this law could be constitutional, then we have to uphold it. It was the impression that I got from what he was saying. And then we can decide all these other questions in other cases because they're not really at play here. Procedural questions came up a number of times that aren't really the core of this case. And then, these other scenarios like who constitutes as dangerous. I mean, it seemed like they all pretty much agreed that Rahimi is dangerous based on the facts in his case. His threats and his shooting at people and all the stuff he's done or accused of doing, at least. And it feels like at least there's some momentum for that on the court. Like you said, I don't want to get way out ahead of things, but I got the feeling that was something they were at least discussing as an option.
I think there's maybe a collective sense that, okay, we did Bruin, and Bruin sets up a correct originalist test for how to apply the Second Amendment. But then we need to give lower courts, and now that we did that, we have these cases coming up like Rahimi and Range and Garland and Daniels, and we need to clearly the lower courts need some help from us in how to apply that as a practical matter. And I think the court is sympathetic to the idea that it kind of has a duty to the lower courts to give them some guidance about what to do next.
Okay. And, going back to this sort of what felt like a consensus view, again, like you mentioned, we can't take too much away from oral arguments, but there wasn't a lot of questioning of the idea that Rahimi himself is dangerous. There seemed to be, going back to Justice Barrett's question about Range, she sort of established that maybe this case is in I think she called it the heartland. So like the core of the idea of somebody being dangerous. But there's these other instances like Range where it's less clear that the person is actually dangerous. And so, I mentioned a retreat earlier. It seemed like the government retreated, but it also felt like Rahimi's counsel retreated a number of times as well. They started off with, he had a couple of good lines about the history of this law, that there really isn't certainly not a historical twin, as got brought up. Not that that's required by Bruin, but he talked about how this law the tie he was wearing is older than this law, and so he started on this point that there's not really a tradition of this exact kind of punishment for this type of offense. But from there, he kind of admitted a number of points that you can disarm dangerous people. Maybe he tried to make the distinction a little bit lower, like, well, if they're an imminent threat at the moment, you can disarm them. But if they just have a gun in their home, you can't put them in jail for 15 years or 25 years just for having a gun in their home. What did you make of his arguments as the case went along?
Well, it's like you're saying, this happens all the time in oral argument. Is you write a brief which sets forth the strong view of how you think the law should be interpreted, and his brief, which I thought was very well written, said that if you look back to history and tradition and in the founding era, the colonial era, the early republic, for people who have political rights, not slaves or free people of color, but for people who have political rights, all the gun control laws involving some misconduct by somebody, they did restrict public carry, or they might confiscate a person's gun, but they never made it a crime even for that person to have a gun in their own home. And that's an accurate description. But when you get into court and the court doesn't seem sympathetic to your top line argument, you try to come down from that and make tactical retreats, just like Solicitor General Preloader did. And that's kind of what oral argument is for. Is you start off with what you want the most, and then under pressure from the judges, you see what you try to pull back to a more defensible position that'll still result in a win for your client.
Yeah, and maybe there just isn't a secondary position when you're in Rahimi's situation, right? It's kind of an all or nothing thing for him, because if you get beyond the idea that
right, because
like you said, that top line argument.
Yeah, and remember the public defender, like any criminal law attorney, his duty is to his client. Period. Yeah. That's the key thing. That's all he's supposed. You can think about the implications and things like that, but his duty is to zealously represent his client and do the best he can for that particular client. And the problem is, if you say, well, let's make this an as-applied challenge. Well, as applied to Rahimi, he's clearly a dangerous guy, right, because there's the Texas state court order, which was based on an affidavit filed by his girlfriend with lots of details of essentially, he was beating me up by an automobile in public, and then some guy comes along and starts complaining about that, and so Rahimi fires a shot in the air to warn away the intervener, and then and
he did a lot of other stuff.
Well, but that's not the basis of the court order of the.
Sure,
he's accused of other.
I think he's also accused of other. Yeah, but even before, like the Whataburger shooting and the running people off the road, all that stuff, that he also was accused of like other aspects within just the domestic violence situation too. You're right. I mean, as applied to Rahimi, sure, he doesn't. Yeah, the facial challenge is kind of all he has, right?
Right, and that's why, as a tactical decision, they made it a facial challenge. You don't need to look at my client. You just need to look at the statute and find the statute's unconstitutional.
Yeah, and it sure seemed like a lot of the justices on either side of the ideological spectrum were not.
They were,
not convinced of this.
Right. So there are what's called facial challenges to a statute, where you say this there is no set of circumstances in which this statute is constitutional, and then there's as applied challenges where you say, well, the statute's constitutional maybe in some applications, but not for my client. And the justices seem to be in a consensus that Rahimi was not going to win a facial challenge.
All right, and so I guess just to wrap everything up here, where do you see things going with this case? I know you don't have to get into to too much specifics. I know, as we've emphasized a number of times, oral arguments can't tell you everything about where the court's going to come down, but how do you see it playing out? Where do you see things going from here? What are you looking for?
Well, I think we have a good chance of getting a decision sooner than the last week of the court's term, because the court, in its sort of normal ecological cycle of when the briefs were due, ordinarily would have had this case orally argued in early December, and they moved it up to have it orally argued in early November. So I think that's a sign they want to get this done. So I'll make a tentative prediction that we'll get a decision on this before June of next year. I think the result of the case will be that Rahimi will lose individually, but I'll tentatively predict that it's not going to be a bad decision for the Second Amendment overall, and that the Supreme Court decision will explain in a more narrow and focused way why it's okay to disarm people like Rahimi without signing on to the very broad theories advanced by the Solicitor General that the Congress can define anything it wants as a dangerous category, and then everybody is just stuck with that congressional decision.
Interesting. All right. Well, we'll have to look and see what the court does when it hands down its opinion. Personally, I think it's a pretty reasonable take. That's where I would come down on it as well. I'll be really interested to see what they do with those other two cases that you mentioned, Range and Daniels. I think that'll say a lot about what they're going to do in Rahimi if we get news on that before Rahimi's opinion comes out, which I guess is not a guarantee either. So, the court, you can't really know until they do something what they're going to do. But we really appreciate you coming on and giving us this recap, sharing some expertise on this. After oral arguments, it's the next big it's the next Second Amendment case they've taken. But this is only the seventh one they've ever done, right? Second Amendment case in their entire history of the Supreme Court, right?
1, 2, 3, 4.
If I'm counting correct. Is it Miller, Heller, McDonald, Saitano, which I count?
Right.
Presser, so maybe sixth?
Presser and Cruikshank before that.
Yeah, that's true. I guess so.
Yeah.
But anyway, people don't think of those ones, but that's true.
They haven't done a lot. And that's
compared to the First Amendment, right?
That's right. And then, Justice Thomas and Gorsuch and Scalia in the years after McDonald and before Bruen complained a lot that, look, we do First Amendment cases all the time. We do Fourth Amendment cases all the time. And it's kind of ridiculous that we haven't done any we're not helping the lower courts more on Second Amendment issues. So I think we're perhaps moving to the Second Amendment continuing to become a normal part of the Constitution, where the court does one or more Second Amendment cases every term.
Well, that'll be interesting if that comes true. It's certainly good for gun reporters, I guess.
Absolutely.
More to write about. But all right, and for guests who are experts on the topics, we'll have to have you back on again.
All right.
Probably in the near future. But we appreciate you taking some time to talk with us. And if people want to follow your writing and what you do, where can they do that?
They go to my website, davekopel.org, davekopel.org, and they can also follow me on Twitter at Dave Kopel, DAVEKOPEL.
All right. Wonderful.
And I write for the Volatile Conspiracy website too.
Yes, very
Reason
good,
Magazine.
very, very knowledgeable site. I highly recommend them and following your writing there as well. Maybe we can get you to write at the Reload sometime in the future too. That'd be great as well. But all right, we're going to head over to our news update now.
All right, ladies and gentlemen, welcome to another episode of the weekly Reload News Update. Sorry, I'm contributing writer Jake Fogelman, joined, of course, by Reload founder Stephen Gutowski. How are we doing this week, Steve?
Good. That was almost the introduction to the main show. We have to have you do a main interview at some point. I definitely want to have that happen, and because I think it'd be interesting to mix things up that way every so often. I've got that intro like memorized now. In fact, sometimes I kind of worry that I'm just speeding through it too fast because I've like said it so many times. So people can go ahead and give me feedback on whether my intros are too speedy now.
You can tell that I listened to every episode too, because clearly it was imprinted in my brain when I started there.
But otherwise I'm doing pretty good. Actually we have the charity shoot is coming up. The Homes for Our Troops celebrity auction is now live, so people can go over and bid on the range day that I have available as part of that. You get a full range day with me. It says for 2 or more, but we've had a couple where people bring their family or whatever. That's totally fine. It's so it'll take place we've done them all in southeastern Pennsylvania, but they're also, we could do them in Northern Virginia or somewhere along that area. So anyone interested in doing that, and all the money, by the way, goes to Homes for Our Troops, which is a charity that builds houses for severely wounded veterans. So it's a really great cause, and they also are well documented. It's a registered charity. You can go and see the work that they do on their website for yourself. And so, which is very important to me, that it's a very legitimate charity. That's has a track record that people can look at. But yeah, all the money that you would donate through the auction goes directly to them. And then you get to have a range day with me. We would just schedule a time that works for both of us. And, I've done it the last couple of years, and it's been a great success. We raise a couple $1,000s usually through my auction. And then I think overall they raise quite a lot of money, because some of these offerings are pretty incredible. I'm talking like red carpet visits for premieres at movies. This is like a real celebrity auction. I don't know that I'm probably the least famous person in this thing. Like, George Clooney auctions off one of his fancy watches every year, and that brings in a lot of money, which is great. You have, Paul Rudd, literally every famous person you could think of. Jake Gyllenhaal is involved. Most people at CNN, Jake Tapper's the one who organizes it. So, lots of movie stars, sports people. There's packages I think there's like a 10 ticket package to Rams 49ers game where you get like a box seat. It's pretty high level stuff that they're offering up over there. So I'm always kind of like, please bid on mine, so the money is not embarrassing compared to what all this other stuff is going to bring in. But it's such a great cause that it's a great thing to be a part of, and we have help from Reload members. Merrill Walters is the guy who lets us who hosts most of our range days at his farm in Pennsylvania. So it's a really good time, and I encourage people to go and check it out. It's on eBay. It'll be in the newsletter as well, and you can find it on my Twitter or my Threads account or wherever else you might follow me. So I definitely encourage people to bid on that. It's for such a great cause, and it is honestly a really good time. We've got a Texas Star and a bunch of steel targets to shoot at all the other times we've done this. So I bring out all my guns, and it's for all experience levels. If you've never shot before, that's totally fine. I'm a certified firearms instructor. If you've shot a lot and you want to bring out some interesting guns, that's great too. We had one of the previous winners brought in an Arisaka.
That's pretty
which
cool.
was pretty cool. So, it's for a good cause, and it's a good time. So check it out if you can.
Yeah, no, absolutely. Not much gets better than getting to shoot guns and get to say it's goes to a good cause. So that's awesome. Yeah. Hopefully people bid some money.
Yeah. I think it's already up over $1,000, and it just launched. So it's good. Hopefully we get I'd love to see a record event this year, so we can build more of those houses. But what are you doing? What are you up to this weekend? You got anything fun coming up? I think you're going on a trip, right?
I am. So the day after we record this, I'm getting on a plane and flying down to Atlanta. My girlfriend and I are going to visit a family friend of hers that lives down there. We're going to go see a Georgia Bulldogs football game. And then we're going to actually drive, after that game to this guy. He has a farm in southern Georgia, and he also has his own home range. And so I'm going to get to shoot some guns
nice.
on a bunch of land, and it should be a pretty fun time. So
that's the dream, a home range.
Yeah, absolutely.
Someday I'd love to have that. That's cool. So you're going to see like the Philadelphia Eagles, like the recruit squad down there. The
Yeah, no, that's right.
Bulldogs.
That's right.
That should be fun. Yeah, no, that sounds like a great time. Georgia's a beautiful state.
Yeah.
I've spent some time down there. Atlanta's a fun city. You can get some really good food. So hopefully you'll be able to do that, or at least get some Waffle House. I don't, do they have that in Colorado? I don't
They do. We do have some
they
Waffle
do.
Houses.
All
Yeah.
right. We don't have. I don't think we really have it around here in Virginia, Northern Virginia, or Pennsylvania. I think there are like, maybe within 100 miles, but not many. So it's quite an institution, American institution.
That's right.
But anyway, what do we have in terms of news this week?
Yeah. So, excuse me. We're recording this on Thursday. So last night, as of this recording, was the third GOP primary debate among the presidential candidates, and sort of a continuation of a theme that we followed in the previous debates. Gun policy was not really a part of any of the discussion among the candidates, which I think is interesting.
Yeah. It was brought up at least in the previous two for, a single throwaway question. Yeah. More or less throwaway, or at least a question that kind of dovetailed into like crime policy. And so you really haven't seen these candidates talk much at all about gun policy, either on the debate stage or as a major part of their campaigns, which has been kind of surprising, honestly. You've seen, as we talked about in the lead up to the race, Ron DeSantis in particular, the Florida governor, had gotten himself some credentials on gun policy. He signed permitless carry. He signed a banking bill that forbade essentially banks discriminating against gun businesses. What been part of that was based off a story we had written about a gun dealer in Florida and the issues he ran into with Wells Fargo. But he hasn't really talked about that much at all on the campaign trail. Because it sure seemed like he was trying to create a distinction between him and Donald Trump, because Donald Trump has some weaknesses on this issue, from the right at least, given the bump stock ban and some of the comments he made after Parkland about taking people's guns before due process, things like that have been, and of course he's also under felony indictment, so he can't buy guns legally right now. But none of this has come up at all. So I guess the candidates just don't see this as an issue where they can distinguish themselves from the front runner who's like way ahead of them. I don't know. The primary is in this weird place, right? Especially these debates where they feel like they're debates between the only peoples who are in the campaign, when really they're all way behind the front runner.
Right.
So I don't know. It's kind of strange.
Yeah.
I'm sure they don't maybe want to focus on the one guy who doesn't show up to the debates, but it's hard not to when he's winning by that much. The whole thing has been a bit odd, and the approach to gun policy has been completely different from what I expected it to be. It's just really a non-issue so far in the campaign.
Yeah, no, I think that's right. And I'm sort of two minds about it. Either one, the candidates don't think it's a salient primary issue, which is itself an interesting political story. Or two, it kind of relates to your Donald Trump point, where they haven't really taken an opportunity to take shots at him on anything. So maybe they're just lumping, because guns would be one of those things, as you mentioned, that they could try to separate themselves from him with, but they haven't really even taken any attacks on the front runner. So I don't know what to make.
I mean, they mostly have stuck with, the electability, which is a hard sell right now because Trump is, winning a lot of these polls.
Yeah.
So, and DeSantis isn't even doing better than him. Haley is in a lot of ways in a lot of those polls, but not to the extent where she's like 15 points ahead of him against Biden or something. So, that's been a fairly hard sell that they've at least been trying to sort of make. But yeah, policy wise, not as much distinction. And maybe they just feel like he's so strong rhetorically in support for gun rights. He goes to the NRA, he gives speeches. The way he talks about gun rights is very invigorated, or he sounds like somebody who's wouldn't have vulnerabilities from the right on guns, but policy wise, the bump stock ban, as we're going to mention here in a moment, has been found unconstitutional a number of times. It was the basis for a lot of President Biden's following rules. He's doing basically the same playbook for pistol braces and ghost guns, so-called ghost guns and precursor parts, things like that. But maybe they just have pulled that and found it wasn't something where Republican voters see it as a vulnerability for Trump. I don't know. It's been odd, though. Like, if you're going to run a race against the guy, you should probably run a race against him on all the areas you can find a contrast. I don't know. I'm not a campaign person, so but at the same time, whatever they're doing doesn't seem to be working either. And that could be just that they don't have a real shot at beating him, or maybe they're just not willing to cross certain lines. Like, a lot of them, the fact that Trump can't legally buy guns, that seems like something they're definitely not willing to go after, because they're not willing to go after any of the stuff related to the crimes he's been charged with. So,
right.
It just kind of sits there, and they don't even distinguish between each other either. This is the other thing. Yeah. Like, even in these debates where it's kind of like a weird, Trump is not, the 800-pound gorilla is barely mentioned. They still aren't trying to contrast with each other in those debates on guns. Nobody brings it up themselves. The moderators haven't really asked much about it. You've gotten one question at the two previous debates that were gun related. And they went to like Chris Christie, right? I think was the one person who had like enough of a statement on guns in a debate that we actually wrote a story on it, which was about mass shootings and how he didn't think gun control would make a difference there. That's candidates could bring up things if they really thought it was something they wanted to get out in front of, and none of them have done that. So, yeah, I mean, that's where we're at as far as the primary goes. Yeah.
We'll keep an eye on it. Maybe as the field winnows down, something might change. But for now,
there's one more debate they just announced, which will actually feature my former boss over at the Washington Free Beacon, Eliana Johnson's going to be a moderator.
Saw
so
that.
I'm looking forward to that and see how that plays out. It'll be on I think News Nation, the new cable news channel. So it should be interesting. Megyn Kelly is also going to be a moderator for that one. So we'll see how it pans out, who's still there at the end. This one was a little less unwieldy, probably just because there were fewer candidates than the previous ones, and they weren't as loud as much over talk as they had done previously. But I also like TV. These spectacle-based debates are kind of really wearing on me at this point. I don't know why you fill these rooms with people who are there to cheer and jeer. It totally changes everything about the debate, makes it into like, I don't know, like a gladiatorial competition. That's, I don't know, maybe that's more entertaining, but I think it's less fruitful for what you're trying to get out of these things. But
yeah, I don't disagree.
What do I know?
Right.
Anyway, we also have another political story, right?
That's right. So Tuesday of this week was obviously election night for a lot of states around the country, including one of the big states that a lot of eyes were on, including we did a little bit of reporting on this in the lead up to the election. So Virginia, all eyes were wondering if the Republicans could potentially capture a trifecta. There were some hopes. And as it turned out, those hopes sort of fizzled out, because it looks like the Democrats will not only retain control of the state Senate, but it actually looks like they took back control of the House as of this recording.
Yes.
So
that's correct.
Not the results Republicans were hoping for.
No, not the outcome that Glenn Youngkin, the Republican governor, had wanted, obviously, and probably the outcome that's going to have the least effect on gun policy, I would imagine, here in the state. Especially because while Democrats took back control of the House and retained control of the Senate, the margins there are, I think, one vote in each chamber at this point. I don't know if all the races have been fully called yet, but it sure seems like there's not going to be much wiggle room one way or the other. And then obviously the governor is still a Republican at this point. So I wouldn't expect much change in gun policy following this. So it's sort of a status quo situation for Virginia outside of the potential court challenges to some of the laws that have been passed by the Democrats back in 2020. They did redistrict the state just before this election. So a lot of incumbents had retired rather than face their new districts. And so, Virginia is kind of a lean blue purple state at this point and has been for a little while now. The best hope that Republicans have had in the past is that our elections happen in the off years. So you don't have that presidential turnout changing things, which has traditionally favored Republicans in off years, lower turnout elections, although that may be changing with how sort of the demographics of who votes for which party have changed a little bit recently. The Republicans have lost a lot of suburbanites and better educated voters, or people with higher degrees, which tend to be higher propensity, or they're more likely to turn out in low turnout elections. So that might be part of it. It's not like Virginia Republicans had a terrible day, I guess. I mean, they lost control of a chamber, so the outcome is a negative for them. But I think they had won most of the seats that were, up to Biden plus 9. So they were closer to that Youngkin election, the 2021 election, than they were to the 2022 election, which Biden carried the state by, I think, 8 points, something like that. So it's a blue leaning purple state at this point, and coming to nearly they were within 1 or 2 seats of controlling both chambers. It's not like a total collapse, but it's obviously good news for Democrats in Virginia, and really just even news for gun policy. I don't see much changing one way or the other, but you never know. I mean, Youngkin isn't exactly a gun rights crusader. At least he's never put himself out there as one. So maybe there's some compromise package that could make it through. I don't know what it would be at this point, because a lot of the lower hanging fruit stuff on the gun control side was already passed in 2020. So you really have like an assault weapons ban being the next logical policy step here. And I don't see that. I don't see Youngkin going for something like that. But yeah, that was the outcome. We had Philip Van Cleve, the president of the VCDL, Virginia Citizens Defense League, on not long ago, and I kind of got the feeling from the interview with him that he was worried about this exact outcome, that people just weren't very energized to come out and vote on guns in Virginia. So it seems like that's kind of what happened. Certainly wasn't I don't know that it was a leading issue in the race. Yeah. It was kind of almost comical as watching, I think, football on Sunday, or even maybe Monday night, and every single ad was a campaign ad here in Northern Virginia, and they were all about abortion.
Yep.
Every single Democratic ad was about abortion, and we saw as well there was spending from the gun control groups here. Significant spending, several $1 million, I believe, was put into the state by Everytown, or at least over $1 million. And even their ads did the thing where they led with abortion and then mentioned guns as a secondary issue in their own ads. So, I think they pretty well outspent the NRA. So it does give you perhaps some insight into the money fight going forward for guns, which might start skewing lopsided towards the gun control side more than it has in the past, given the struggles that the NRA is undergoing. But speaking of the NRA, we actually have some more Supreme Court news, right? We just talked about the Second Amendment case that they had oral arguments in this week with. We talked with David Kopel at the beginning of the show, but they've actually taken up 2 new gun cases, and one of them relates to the NRA, right?
Yep, that's right. So we have a couple stories you folks can check out in the newsletter. But as you mentioned, the Supreme Court agreed to hear a case called NRA versus Vulo, which is, even though it involves the NRA, is actually more of a First Amendment case than a Second Amendment case.
Right.
Deals with a financial services. I think it's the Department of Financial Services in New York. The head of Maria Vulo at the time basically made some thinly veiled sort of threats, but not really threats, to insurance and banking organizations, warning them of the reputational risks that they would be doing by working with the NRA. And obviously the NRA challenged that and said it was an infringement on their First Amendment rights to try to basically use government coercion to try to get financial companies to divest from working with the NRA. And so the Supreme Court's going to hear that this upcoming term, which I think is interesting.
Yeah, and the NRA has, in the lower court case, they had the ACLU on their side.
Yeah.
So sort of, the unusual bedfellows situation, which maybe gives you some insight into the details of the case, right? Like you described, she sent out this letter to these financial companies and it's basically like, you guys should really think about whether you want to work with the NRA or not, based on their political beliefs. She was specifically pointing to the things that the NRA advocates for. And, so the ACLU was on the NRA side in this case. The lower court actually ruled against the NRA and essentially said that the letter was nicely worded, so it didn't constitute like the First Amendment violation, wasn't harsh enough to be that. So I think the Supreme Court accepting this case is a situation where you can read into that, perhaps, that maybe the Supreme Court doesn't agree with the Seventh, I believe it was the Seventh Circuit, the lower court that ruled against the NRA. So the NRA has probably a pretty good shot of winning that one. It's not a Second Amendment case, though. It's a First Amendment case. So similarly, they took another gun case that is not a Second Amendment case, right?
That's right. So as we mentioned earlier when we were talking about the GOP primary debates, the bump stock ban. So after many years of gun rights advocates trying to get the Supreme Court to hear this, they finally agreed to take up a case on the bump stock ban, which once again is not a Second Amendment case. Really, it's more of an administrative powers case. But they will hear oral arguments and eventually rule on the legality of the bump stock ban. So that's pretty big. Yeah,
definitely big. Interestingly, even though it's not a Second Amendment case, and it probably won't tell us much about what the court thinks of the Second Amendment, like Rahimi will, to some degree at least, it will probably have a bigger practical impact on most gun owners, I would think, because most people are not subject to domestic violence restraining orders, or even the criminal prohibitions that might be implicated with the Rahimi ruling. But millions of people own some of the devices or firearms that have been impacted by these rules, these ATF rules that were put in place by President Trump and now President Biden. And that started with the bump stock ban. And so, that's going to have implications for the pistol brace ban, for the unfinished firearms ban, the ghost gun ban, and rules along those lines, I think, will be implicated here. So that could affect millions of gun owners, even though this case isn't directly about the Second Amendment. And you're probably better off looking at the Supreme Court's history on administrative powers and what they've been doing on that front recently, which frankly, they've been very skeptical of administrative powers. You saw that in the APA ruling last year. That will probably give you more insight into where the court's going to go on the bump stock ban case than the Second Amendment cases will.
Yeah, that's right. But speaking of those related rules that could be implicated, we have a new federal ruling on one of them, the pistol brace ban, where a judge issued a nationwide injunction, which is, I believe one of the first judges to actually issue, or you shouldn't call it an injunction. It's a stay. We talked about this.
It's a little confusing.
Off mic, we were a little confused about the specific terminology, but essentially he blocked the rule nationwide rather than just to the plaintiffs of gun groups, which is what we've seen to this point.
Yeah, he stayed the entire rule for the duration of the challenge to it. In that case is another Fifth Circuit case. So the ruling is really just mostly quoting what the Fifth Circuit panel had said when they ruled that the ATF's ban was unlawful, and what other judges have written on this topic. And so the really interesting thing about it is that it seems to apply to everyone and across the country, which is something that previous judges, including that panel, have not been willing to do, to extend the block on enforcement to everyone everywhere. And now they've done things like all members of the Firearms Policy Coalition or the Second Amendment Foundation or some of the other direct plaintiffs in some of these cases, but not to everyone. So now, this is a much bigger block of enforcement. I mean, it's a stay instead of a preliminary injunction or a temporary restraining order. So legally, there's a distinction there. I will have to talk to some of my lawyer friends to understand exactly what it means. But yeah, it's a significant ruling that we haven't seen before. We haven't seen a ruling with nationwide implications like this, and that's probably because in the recent years the Supreme Court has become a little bit unhappy with nationwide injunctions from a single district court somewhere in the country. So you've seen less of that recently, but we'll have to see how long this lasts, what the DOJ does about it. They haven't responded to requests for comment, so we don't know exactly what their plans are at this point. But yeah, significant for lots of people who still own those devices, because most of them, if you recall, were not registered by the deadline, according to the ATF. So big news there for sure.
Absolutely. And then the final story we're going to talk about today is one that you actually broke. You had an exclusive on the uptick in Israeli citizens applying for gun permits. And we actually got confirmation on a hard number on what that looks like. If you want to tell us what you found out in your reporting.
Yeah. So I spoke with a member of the Israeli parliament who oversees the gun licensing there. And he said that they've had 150,000 applications. That was the estimate he gave over the past month, in the month since the October 7th attacks by Hamas. And that is an unprecedented amount in Israel. He said that was the equivalent of 3 years of applications. Usually they get between 40 and 50,000 a year, and they had 150,000 in less than a month. So it gives you really good insight into the reaction from Israeli civilians to the sort of horrific slaughter that we saw, that the whole world saw on October 7th. So, I think that's pretty significant. It's, it dovetails with what we saw in Ukraine during the initial invasion by the Russians. And it also dovetails with what we've seen here in the United States from Jewish Americans who are also understandably concerned about the terror attacks in Israel on October 7th. And they have also gone out and bought a lot of guns and gotten new training, and which is reporting that we've done previous to this as well. So, a pretty unprecedented situation in Israel as far as civilian gun ownership goes there. And one that I think could have implications, as well for the future of gun regulation in that country, and maybe in other countries as well. I don't know.
Yeah, no, it's interesting because obviously Israel is different than America. I know a lot of American gun owners like to look at these things through American cultural eyes, but they don't have a Second Amendment in Israel. It's not the same type of gun culture. So to see this enormous uptick in people looking to exercise some form of gun rights, even though it's not a Second Amendment based right, is certainly notable in a country like that, especially when they have the precedent of what, the heroism that they saw from sort of paramilitary, basically civilian gun owners in these kibbutzes during that horrible attack where people in the community took up arms and defended whole communities during that terrible terrorist attack. So certainly looks like a potential cultural turning point, but we'll obviously have to wait and see.
Yeah, Simcha Rothman, who was the Israeli politician that I interviewed for this piece, he pointed to those exact situations as inspiration for people in Israel. So some of these successful defenses of the communities in the South, where they have they're like community security agencies. Essentially, they're not. He called them semi-military. I don't know that we have an equivalent to that here in the United States.
Right.
But maybe National Guard to something like that. But it's a little different. It's just not a similar political situation. We don't have Hamas on our border like they do. So, it's not quite the same thing. Maybe a sheriff's department you might compare it to. But regardless, that example of people defending their community successfully during these attacks, while 1,400 people were murdered, has driven a lot of other people to go and get armed. And yeah, the cultural difference is very significant with gun ownership in Israel compared to the United States. Like you said, it's not a right there. You also basically you can only own handguns was the implication he's giving. These permits only apply to handguns. They are kind of a combination of a permit to own and permit to carry. So you don't have to get a separate carry permit if you get a gun permit. But you have to live in a special zone that the government considers particularly unsafe to get one of these, or you have to have been served a specific kind of role in the military previously, a combatant. They have opened up some of these things, some of the eligibility since the attack. Now I guess combat veterans are the largest group who are eligible for these. And so, and keep in mind, this is a country of about 9.5 million people. So 150,000 permits in a month. That's a lot for a country that size, especially considering on the other end of it, they don't have the same tradition of civilian gun ownership as we do in the United States, but they also have a culture where military service is mandatory for most people. So they aren't necessarily unfamiliar with firearms either. They're familiar with them in a different context, which is, mandatory military service. And obviously they have a lot of the able-bodied men are being called up to the reserves and they're being armed with military firearms, with rifles and that nature. So they take a very different approach than we do to guns, but it's not something where, everyone there is unarmed all the time and have no understanding of how to use firearms. It's just a very different cultural approach than we have. We also have a members piece that dives into some of those differences a little bit more. And there's obviously a lot of similarities as well. But yeah, big piece. I think it has says a lot about what's going on in Israel at this moment. So people should head over and read that. But that's all we've got for you this week. We will be back again real soon. But in the meantime, if you want to support the show, you can give us a rating on your podcast app, whatever you're listening to us on, or a thumbs up on YouTube. You can share this with anyone you think might be interested. That's always super helpful to grow the show. And of course, you can also head over to thereload.com and sign up for our free weekly newsletter if you want to get a taste of more of the kind of reporting we do. And if you like it, perhaps you can buy a membership and support us financially, as well as get access to hundreds of pieces of analysis and stories that you won't find anywhere else. We are doing something completely different than any other publication, I believe. And I think it's worthwhile. It's great for you to show your support that way, but also get access to valuable information. And of course, you'll get the show a day early and the opportunity to appear on the show in a member segment. If you want, just reply to your Sunday members newsletter if you'd like to be on the show, and we'll do a member segment with you. But that's all we've got, and we will see you guys again real soon.